Energy, energy, energy. I am Sade Renee L, all rights reserved, and I'm back at it again with another video. Today I'm going to be doing a quick video on Abraham Lincoln and William Dungey, the Black Bill versus Black laws. And per usual, I appreciate you guys tuning in. I'm going to just read straight through it. Please like, share, subscribe. Among 10 original Abraham Lincoln documents discovered last summer in the DeWitt County Courthouse at Illinois is a bond for costs in William Dungey versus Joseph Spencer. Written but not signed by Abraham Lincoln, the bond was part of an interesting slander case. Family disputes that degenerated into slanderous name-calling feuds frequently appeared in antebellum Illinois circuit courts. Such cases reflected the intent of American slander law to safeguard an individual's good reputation in the community against petty character assassination. Abraham Lincoln, scroll down, Abraham Lincoln realized the value of reputation and declared in his first printed political speech that every man is said to have his peculiar ambition. I have no other so great as that of being truly esteemed of my fellow men. One unique slander case Abraham Lincoln argued at the DeWitt County Circuit Court, Clinton, Illinois, in the May and October 1855, terms involved much more than a defamation of character, and suggested that Huck Finn's friend, Jim, might have reconsidered his plan of escape to freedom. I reckoned at by 4 in the morning, I'd slip in just before daylight and swim ashore and take to the woods on the Illinois side. In August of 1851, William Dungey, a dark-skinned young man of Portuguese descent, married a European woman, Joseph Spencer's sister. A family quarrel ensued, which became so bitter that in January 1855, Joseph Spencer, a European, claimed throughout the community that his brother-in-law, Black Bill, was a Negro. Since 1819, Illinois state laws permitted quasi-slavery and restricted the immigration of free Blacks into the state, as other northern states passed personal liberty laws granting additional rights to free Blacks. Illinois state toughened its stance against them. The 1848 Illinois State Constitution required the General Assembly to pass such laws as will effectively prohibit free persons of color from immigrating to and settling in the state. Those prohibitions against human rights were passed as the Black Laws and went into force on February 12, 1853, the same date of the future emancipator Lincoln's 44th birthday. William Dungey faced losing not only his reputation, but his marriage, his property, and his right to remain in Illinois. Section 10 of the 1853 Black Law stated that every person who shall have 1/4 Negro blood shall be deemed a mulatto. William Dungey retained Abraham Lincoln to squash the possibility that he might be judged a Negro and therefore suffer the severe penalties under the 1853 Black Laws Act. Abraham Lincoln filed his declaration charging Joseph Spencer with slander on April 17, 1855, and sought $1,000 in damages. A game of legal chess occurred during the first hearing in May. Joseph Spencer's attorneys, Clifton H. Moore and Lawrence Weldon, also Europeans, filed a demurrer to Abraham Lincoln's declaration, asserting that his charges were insufficient in law. Judge David Davis agreed that 2 of Abraham Lincoln's 3 charges were faulty. The case was continued, and Abraham Lincoln was allowed to amend the declaration. At the next term of court, October 1855, the Dungey case was argued before a jury. According to Joseph Spencer's attorney, Lawrence Weldon, Abraham Lincoln's talents as a trial lawyer, were evident in his argument for William Dungey. Lawrence Weldon stated that Abraham Lincoln questioned Joseph Spencer's character by demonstrating how Joseph Spencer went from house to house, gabbing that William Dungey was a nigger. Attorney Lawrence Weldon emphasized that Abraham Lincoln's tone and pronunciation had a curious touch of the ludicrous, which instead of detracting, seemed to add to the effect. Abraham Lincoln further undermined Joseph Spencer by using humor to persuade the jury that there was reasonable doubt regarding William Dungey's race. The attorney Lawrence Weldon recalled Abraham Lincoln's statement. "My client is not a Negro, though it is a crime to be a Negro. No crime to be born with a black skin, but my client is not a Negro. His skin may not be as white as ours, but I say he is not a Negro, though he may be a Moor." Abraham Lincoln. "Mr. Lincoln," interrupted Judge Davis, scarcely able to restrain a smile. "You mean a Moor, M-O-O-R, not Moore, M-O-O-R-E? Well, Your Honor, Moore, M-O-O-R, not Clifton H. Moore," replied Mr. Lincoln, with a sweep of his long arm toward the table where Moore and I sat. "I say my client may be a Moor, but he is not a Negro." Abraham Lincoln. Though the account may be apocryphal, attorney Lawrence Weldon's recollection was characteristic of Abraham Lincoln's style. Abraham Lincoln then demolished the defendant's witnesses' testimony. Attorneys Clifton H. Moore and Lawrence Weldon had secured several depositions from residents in Giles County, Tennessee, the Dungey family home. These witnesses stated that they had personally known the family and that the white community had regarded the Dungeys as Negro or of mixed blood. Under cross-examination, Abraham Lincoln argued that the testimony was hearsay, as the witnesses admitted none of them lived within 30 miles of the William Dungey's residence. On October 18, 1855, the jury returned a verdict of guilty and granted William Dungey $600 in damages plus court costs of $137.50. Abraham Lincoln charged a $25 fee, which Lawrence Weldon considered minimal. To avoid an appeal to the Illinois State Supreme Court, Abraham Lincoln persuaded William Dungey to remit $400 of the judgment in return for the defendant releasing all errors which may exist in the court record. Under Illinois state law, the defendant could not appeal the verdict, but could appeal only on errors of procedure or evidence. Abraham Lincoln had taught Joseph Spencer an extensive lesson in domestic relations. Note, legal and lawful analysis on status and estate and other ancillary supports. The reader, researcher, or scholar is advised to review the foregoing synopsis of the William Dungey slander case of 1855 with keen consideration about the realities and facts that in law and in legal process, one's status also determines one's standing in relationship to one's estate. Thus, as in this case, the spurious tags, brands, and nom de guerre, such as Black and Negro, being pejorative in status, compromising nom de guerre and misnomers, had, can, and will create serious and debilitating social and economic repercussions in relationship to William Dungey's estate. Such a damaged reputation would place all of his present and future hereditaments at risk and subject to escheat. Keep in mind that the European Roman colonial unum sanctum bulla and the doctrine of discovery conquest policies are operative and in effect upon the lands and the aboriginal natural peoples of North America. These and other supporting bullas were imposed upon peoples of the Western Hemisphere. Therefore, one must be aware of the Inquisition acts and edicts of the past, and thus be more cognizant of the social, economic, and political actions, and politics of the present. A nom de guerre is in its most literal meaning and application a war name, a pseudonym. Status is the standing, the state, or the condition of the person. It relates to the legal relation of the individual to the rest of the community. Status relates to the rights, the duties, the capacities, and to the incapacities which determine a person to a given class. It is a legal personal relationship, not temporary in its nature, not terminable at the mere will of the parties, with which third parties and the state are concerned. And while the term status implies relation, it is not a mere relation. Status also means a state, because status signifies the condition or the circumstances in which one stands with regard to his property. Estate is the interest which anyone has in lands or in any other subject or property. An estate in lands, tenements, and hereditaments signifies such interest as the tenant has therein. In this sense, estate is constantly used in conveyances in connection with the words right, title, and interest, and is in a great degree synonymous with all of them. Hereditaments are things capable of being inherited, be it corporeal or incorporeal. That includes all things real, personal, or mixed, and including not only lands and everything therein, but also heirlooms and certain furniture which by custom may descend to the heir together with the land. At common law, corporeal hereditaments were and are physical objects comprehended under the term land, and were said to live in livery, while incorporeal hereditaments existed only in contemplation of law, and were said to lie in grant, and were affiliated with chattel interest. Hereditaments also includes a few rights, unconnected with land, but is generally used as the widest expression for real property of all kinds, and is therefore employed in conveyance after the words lands and tenements to include everything of the nature of realty which they do not cover. And that was like Ancient and Modern Jurisprudence, Henry Campbell, Black Law Dictionary, 4th edition. All right. Descent and descendability. In the matters of operation of law and of rights, descent in its broadest sense signifies an inheritance cast upon anyone who is deemed capable of receiving it, whether heir at common law or not. Thus, descent may occur by hereditary succession or by succession to the ownership of an estate by inheritance or by any act of law. Descent is distinguished from purchase. Title by descendability relates to the operation of descent in the matters of an estate or inheritance, being capable of being passed, inherited, or transmitted by devise. Spoken of estates, titles, offices, and other property. A natural person or heir deemed in improper persona, nor held as competent by operation of law, may be considered non-heritable and incapable of descendability. In controversial or disputed or contested issues of descendability, the birthright, stealing practices of branding, and the removing of consanguine attributes names and titles by operation of law or by fraud can create descendability obstruction for anyone otherwise deemed as an heir or as one capable of descendability. Non-Beguir war names or common brands applied to or imposed upon defeated or enslaved Moors by European colonists at North America were commonly used as strategies for stealing or confiscating estates and inheritances. The William Dungey slander case of 1855, as an example, was a prime incident of an attempt of such common estate practices invoked by European barristers at North America and used against the natural peoples of the land. Escheat. In feudal law, escheat is an obstruction of natural course of descent and the consequent determination of the tenure by some unforeseen contingency, in which case the land naturally reverts back by some kind of reversion to the original grantor or lord of the fee. Escheat, the casual descent, in the nature of forfeiture of lands and tenements within that manner to a lord, either on failure of issue of the tenant dying, seized, or on account of the felony of such tenant. In American law, escheat signifies a reversion of property to the state in consequence of a want of any individual competent to inherit. The state is deemed to occupy the place and hold the rights of the feudal lord. The word escheat, under the jurisdiction of the United States, exercising civil plenary powers on the land at North America, merely indicates the preferable right of the state to an estate, left vacant and without there being anyone in existence able to make the claim thereto. Realty is a brief term used to real property and also for anything which partakes of the nature of real property. Feudal law is the body of jurisprudence relating to feuds. It is the real property law of the feudal system. It is the law anciently regulating the property relations of lord and vassal and the creation, incidence, and transmission of feudal estates. Civilar mertus is a law term that applies to one who is held as being civilly dead, dead in the view of the law. It is the condition of one who has lost his civil rights and capacities and is accounted dead in law. Civilar mertus is a negative status which stands in stark opposition to in full life, which means continuing in both physical and civil existence. That is neither actually dead nor civilar mertus. Etymology, the word black. Black. The word black is an adjective and is of Middle English, ME origin. Linguistically and grammatically, Middle English places the word black between the years 1100 to 1500 as a means of measuring the passage of time. This equates to the timelines of the 12th to the 16th centuries. Scholars and other literate people who possesses the capacity to read associate the Middle English linguistic timeline by way of the Julian calendar in the Common Era. In the history of European culture, this period of time is considered the High Middle Ages, and is also called the Age of Cistercians. Cistercians are members of the monastic order, which was founded by Saint Robert of Molesme in the year 1098 at Citeaux, France, under an austere Benedictine rule.
Benedictine rule. The etymology of the word black is Middle English, ME, and Middle English is derived from the Old English, OE, word black, which linguistically places it from the language of the English people from the time of the earliest documents in the 7th century to about the 1100s. Both of these English words, black and black, are derived from bell. Thus, black originates from bell. Their origin and true meaning of the word bell is to shine, to flash, burn, shining white, and various bright colors. 1. Beluga, from Russian believe, white. Kalaro, from Greek kalaros, having a white spot. Bell is a suffix variant form of belu, blue, derived from Old French. Blue, blue, derived from Germanic bluas, blue. Bell has various extended Germanic forms, such as bleach, derived from Old English Blackie John or Blackie Jan, which means to make white, bleak from Old Norse bleaker, which means shining and white, and is derived from the Germanic blackas, which means shining and white, etc. Important derivatives of bill are blue, bleach, bleak, blaze, blemish, blind, blend, blonde, blank, blanket, blush, black, flagrant, and flame. Etymology. Noun. In plural form, etymologies. Middle English, etymology. From Latin, etymologia. From Greek, from etymon plus logia minus logi. Etymology is the history of a linguistic form as a word, shown by tracing its development since its earliest recorded occurrence in the language where it is found, by tracing its transmission from one language to another, by analyzing it into its component parts, by identifying its cognates in other languages, or by tracing it and its cognates to a common ancestral form in an ancestral language. Etymon is the literal meaning of the word according to its origin, from etymos, meaning true. Etymology, basic to elementary grammar, etymology is basic to elementary grammar and is vital to fundamental reading skills. Primal and important for the reader, researcher, or scholar to acknowledge and to realize is the deliberate and strategic misplacement of or misusages of words, and also to recognize the social engineering and pejorative, nom de guerre, and prima facie applications of the tags, brands, and misnomer usages of the English words Black and Negro, etc. Note that such wrongful and depreciatory misusages as were demonstrated in the William Dungey slander suit of 1855 were not without negative intent. The principal argument related to the spurious usages of the words falsely applied as identities and placed upon the Aboriginal natural peoples Moors. Such violations constitute arbitrary acts of denationalization, statelessness, worship tenures, and create a condition of non-descendability, and thus would justify escheat by the state by operation of law, establishing a lack of heritability. The slander, trespasses, and torts initiated by Joseph Spencer against the good standing of William Dungey was meant to injure and damage his status. Therefore, the lawsuit and declaration in the William Dungey slander case, as filed by Abraham Lincoln, was well grounded in law and necessary as a remedy in law to secure the rights of his state for his client, William Dungey. History and the public record shows that William Dungey's slander suit was litigated and concluded on October 16th of 1855, and that Abraham Lincoln was the lawyer defending Dungey's honor and estate. However, one must also remember that his important slander case was also litigated 5 years before Lincoln held the office of President for the United States of America, November 6th of 1860. Another important fact is to know and remember that in this, Abraham Lincoln was a key player in the issuance of and signing of General Order 100, known as the Labor Code, and that Abraham Lincoln was the last de jure constitutional holder of office, president of and for the Republic. All succeeding presidents of the United States thereafter were and are operating and functioning in a de facto status. The defense of William Dungey and his estate by Abraham Lincoln, the lawyer, prior to his holding of the presidential office, did not sit well with many Europeans occupying North America. The later initiatives which gave incentive to the Lincoln's executive actions while acting as president for the United States and related to the Emancipation Proclamation of 1862, though modified twice by a disgruntled Congress, were influential in the growing practice of Abraham Lincoln being called Africanus the First. Consider and analyze the later to be established and deliberately undermined Bureau of Refugees, Freedmen, and Abandoned Lands, 1865, noting the 40 acres and a mule, subject matters, and associated attempts to restoration. Contrary to justice, the birthright, stealing the estate, issues at North America continue.